Okay, gang, we're ready to roll. Recording has started.
Ready to go?
Yes.
Everyone, thank you for joining us. My name is Jeff Eisler. I'm the president of the FBI Citizens Academy at Tampa Bay. And today we have joining us from the State Attorney's Office, Mr. Andrew Warren and Justin Diaz, to do a little sort of a fireside chat. Everybody's been muted and you cannot take yourself off of mute, so you'll have to request through the chat if you do have a question or a comment. I'm going to go through Mr. Warren's and Mr. Diaz's bios real quick, and then we will let them take it away. Andrew Warren was elected as State Attorney of Florida's 13th Judicial Circuit, Hillsborough County, on November 6, 2016. Warren leads an office of approximately 130 prosecutors and 300 total employees whose mission is to build a safer community while promoting justice and fairness for everyone in the criminal justice system. Since taking office on January 3, 2017, Warren has been reforming our local criminal justice system. He has been tough on violent criminals, fraudsters, and repeat offenders who threaten the safety of our neighborhoods. He has utilized innovative reforms and created successful diversion programs to hold low-level, pardon me, I lost my place here, low-level offenders accountable while steering them away from the downward spiral of the system, including civil citation programs for juveniles and adults. Warren is focused on treatment, prevention, and rehabilitation for offenders with substance abuse and mental illness in order to reduce recidivism rather than further the revolving door of the criminal justice system. He has minimized poverty traps and criminalize people because they are poor. He has embraced data-driven approaches that improve safety, cut crime, and save taxpayer dollars. Additionally, Warren has emphasized transparency and civic engagement to build trust with the community that he serves. Mr. Justin Diaz. Justin Diaz currently serves as the Felony Division Chief and primarily handles homicide cases. Born and raised in Tampa, Mr. Diaz graduated from Jesuit High School and obtained his degree in English literature from the University of South Florida. He went on to receive his Juris Doctorate from Florida State University and then returned to Tampa, where he has started as a prosecutor in the spring of 2002. Mr. Diaz has handled criminal cases of nearly every type in the misdemeanor, traffic, juvenile, and felony divisions. He tried over 100 jury trials throughout his years. Before becoming a Felony Division Chief, he was assigned to Project Safe Neighborhood, where he handled cases involving victims injured by shootings and cases involving violent crime committed by gangs. So with that, Mr. Warren, if you'd like to begin, the floor is yours.
Jeff, thank you so much. Thanks for the introduction. Thank you for the invitation for me and Justin today to talk to the Citizens Academy about what's going on with the Stand Your Ground. So we have like an hour to talk about the evolution of Stand Your Ground today. And I have the pleasure of working with Justin and 130 other ASAs in our office. And one of the nice things about being the boss is I can sometimes delegate the harder jobs to my assistant state attorneys and do the easy part. And so you're going to see that happen today live and virtually in person, because I'm just going to spend a few minutes talking about giving an overview of Stand Your Ground. And I'm going to turn it over to Justin, who's going to walk through a lot of the legal nuance that goes on with outlaw. So let me start by talking about Stand Your Ground by addressing three common misconceptions. The first thing I want to start with is throwing out some names. Trayvon Martin, Marquise McLaughlin, Curtis Reeves. These are examples locally or in the, Trayvon Martin from Orlando, of what people think of when they think of Stand Your Ground. They think of somebody using a gun in self-defense or in claimed self-defense, and then, some sort of criminal chaos ensuing. This is a huge misconception. Stand Your Ground does not just apply to gun cases. It doesn't just apply to shooting cases. It applies to just about every violent crime, every murder, every stabbing, every assault and battery, threats even. This is a common misconception, and it matters for the reasons that I'm going to go into in a minute. But I just want to make sure you understand, when you think of Stand Your Ground, please don't think of just the case that you see on the news where somebody used a gun claiming it was self-defense, and then there's some legal dispute that, becomes some high-profile case about whether that was stand your ground. That is just a small slice of what stand your ground actually is. The second misconception about stand your ground is that it's a substantive law, that it provides some, substantive rights of using self-defense, that we protect people in their ability to protect themselves, their homes, their family, etc. The reality is that stand your ground is much more procedural than it is substantive. And just to explain the difference, procedural, what I'm talking about, are not rights that it gives you in terms of what you can do, which would be a substantive right. I mean procedural, like it affects what happens in the criminal justice system process. So to dive into that a little bit, proponents of stand your ground like to claim that it restores this balance of innocent until proven guilty, that we have people who use the right for self-defense, and without stand your ground, they're not allowed to, and then they're going to be charged and prosecuted, and that turns innocent until proven guilty on their head. That is simply not true. In fact, nothing could be further from the truth in this context. The idea of innocent until proven guilty is not legislative. It can't be addressed by stand your ground or any law. It is based on our Constitution. It is immutable, fundamental principle of our system, that before you can be convicted of a crime, you are presumed innocent, and only after you've been proven guilty by evidence that establishes guilt beyond any and all reasonable doubts can you be convicted. What stand your ground actually does is it creates this technical legal hurdle at a pre-trial evidentiary hearing before we can prosecute a case. So what that means is, usually we charge someone with a crime and then the discovery process goes on. So, if you robbed a bank, shot someone, have drugs on you, whatever it is, you get arrested, the prosecutor files formal charges against you, and then the legal process begins. You're informed of your rights. You have a right to an attorney, of course. We have to turn over all the evidence that we have. Depositions can occur, and then there are pretrial rulings that happen where, the court says, okay, I'm going to exclude that evidence. I'm going to keep in this evidence, and then we get to trial. And that's basically the process. You're accused of a crime, we turn over the information, and then we have a trial about it. What stand your ground does is it creates this pretrial evidentiary hearing where before we can get to trial, we actually have to prove that someone wasn't acting in self-defense. And it used to be by a standard of preponderance of the evidence, which is a 50% standard. So it used to be under the 2005 law that we had to be able to prove it was more likely than not that somebody was not standing their ground. They were not entitled to self-defense, and then we could get to trial. The legislature changed that law in 2017. Now it's an even higher burden of clear and convincing evidence. So we have preponderance, which is like a 50% standard. Then we have clear and convincing, which is a higher standard, still less than proof beyond a reasonable doubt, which is the standard we have to prove at trial. Now, I know I'm getting kind of into the legal weeds here, which I said I wasn't going to do, but the reason why it matters is so people understand how this actually impacts cases. This change in 2017 is the first time in Florida's history that we as prosecutors have to disprove a self-defense before we can get to trial. We actually often have to prove a negative, and there's no burden on a defense attorney on a defendant to even raise a claim. And again, go back to how it's supposed to be. We charge cases, then we get to trial and we prove them. Now what we have to do is we charge cases, then we have to prove them, and then we have to prove them again by a higher standard. The reason why I brought up the first misconception about what cases it applies in is because this is where it gets tricky. This unnecessary technical hurdle affects thousands of cases a year just in our jurisdiction. There's a huge cost to it. It creates more work for our court system, more work for judges, more work for prosecutors, more work for defense attorneys, more work for law enforcement officers because we are taking them off the street to now come into court to have to testify first at a stand your ground hearing, and then if we win stand your ground, then we get to trial. So that's the second misconception. The third misconception is that stand your ground is somehow necessary or it's productive. It's really not. It's just not. This law was a solution in search of a problem from the beginning. It makes it harder for us to prosecute violent criminals. And again, I said the idea behind it was to restore the balance of innocent until proven guilty. Nothing ever touched that balance. What it really did was you had people complaining or putting forth this idea that somehow prosecutors were prosecuting people who were acting in self-defense. And they shouldn't have been, and they were all these cases of people going to trial where prosecutors were losing. And if only we had weeded out those cases ahead of time through this, pre-trial hearing, we wouldn't have put people through the difficulty of being prosecuted when they shouldn't have been. The reality is that that wasn't happening. And in the rare circumstances where it happens, people still have to go through the emotional hassle and trauma and expense of being charged with a crime. It just means the case ends a little bit earlier at a pretrial hearing rather than a trial. So it doesn't even address the problem that people were saying existed. And what does it do that's bad? I said that it emboldens violent criminals because it makes it harder for us to prosecute criminals. It also emboldens vigilante justice. When you think of George Zimmerman, who shot Trayvon Martin, when you think of Michael Draka, who shot Marcus McLaughlin in Clearwater, when you think of Curtis Reeves in the movie theater shooting, these are people who apparently, some of the cases haven't been ruled on yet, but who are committing a crime, and it's made it harder for us to prosecute them. This law ends up being, it's anti-law and order, it's anti-law enforcement, it delays justice for victims, in some cases it even prevents justice for victims, and it doesn't even protect responsible gun owners. What it does is it actually conflates responsible gun owners from people who are using guns in an illegal manner who should be prosecuted for the crime. So that's my 7-minute soapbox on Stand Your Ground. And hopefully it provides an overview of what the law is and what the law isn't before I turn it over to an 18-year veteran of this office, Justin Diaz, who has handled many Stand Your Ground hearings in our courtroom here and prosecuted and overcome Stand Your Ground defenses as he prosecutes gang members and other people who not only use guns, but commit all sorts of violent crimes in our community. Justin?
All right, thank you, Mr. Warren. So I'm gonna share a PowerPoint with you guys in a second, but before I do, I wanna help you all make sure that we understand what we're talking about. And whenever you're talking about stand your ground, you're gonna be talking about a defendant is claiming that he was standing his ground or she was standing her ground. You're talking about the person who has shot someone or stabbed someone, killed someone, beat someone up, whatever the case may be. So as you see the word defendant, remember you're talking about the person who has shot someone, killed someone, whatever the case may be. So let me see if I can get this to share. Share screen. Can everybody see that okay?
Yep.
Got some heads nodding, so I'm gonna take that as a yes. All right, so I put this little cartoon here. This came out a few years ago when Florida enacted self-defense, the Stand Your Ground laws back in 2005. So it's a little dated, but I thought it was funny. One of the things I want to talk about is people use the term stand your ground, but what they're really talking about 9 times out of 10 is they're talking about defense laws, self-defense laws, defensive property laws, okay? Stand your ground, you're going to see, is actually a very small part of the overall laws that cover self-defense or defense of property or defense of another. And in the state of Florida, that's all contained in Chapter 776 of the Florida statutes, which is called the justified use of force, okay? And we're going to talk about that. But basically, when you're talking about self-defense or saying stand your ground, you're really talking about the justified use of force laws in the state of Florida, okay? So when you talk about that, you have to distinguish a couple different things because there's different statutes that govern what we're talking about and how we analyze all of this. There's 2 general reasons to use force. One is for the defense of a person, either yourself or someone else. And then the second reason is defense of property, okay? And those are governed by 2 different statutes that we're gonna look at a little bit, it kind of in passing. They're slightly different, but generally the logic is the same. Irrespective of the fact that you may be talking about defense of self or defense of property, you still also have to talk about what's the method of force that's used. Is it deadly force or is it non-deadly force? And for ease of description, deadly force is force likely to cause great bodily harm or obviously death, okay? And non-deadly force is anything not likely to cause great bodily harm and certainly not likely to cause death. In the state of Florida, that question is largely a matter of the facts of the case. As I put the note there, the only situation where you can always guarantee and be sure that it's deadly force that was used is when a firearm is discharged. That's it. If the trigger isn't pulled and a bullet isn't fired, technically there is the potential to argue that whatever was done was non-deadly force. You use a knife, you use a baseball bat, you hit somebody with a car, whatever the case may be, there is, at least theoretically, the argument that that was the use of non-deadly force. Even pulling a gun out and pointing it at someone could potentially be the use of non-deadly force. The only time you'll ever be only in the deadly force category is when somebody pulls the trigger and a bullet gets fired, okay? So to help you understand what we're talking about, I want to first talk about something called the Castle Doctrine. And the Castle Doctrine is something that dates all the way back to English common law. I was doing a little research while I was getting ready for this. I found it stretching back all the way to the early 1600s, way before we had a revolution here in America and founded the country. I pulled the definition out of Black's Law Dictionary. For those that you all don't know, lawyers have their own dictionary. We use Black's Law Dictionary. And the definition straight out of Black's Law Dictionary is a man's home is his castle. Everyone probably knows that maxim. And he may use all manner of force, including deadly force, to protect it and the people inside of it. And that has been English common law stretching all the way back 400 years. Yeah, Mr. Warren actually has his Black's Law Dictionary there on the screen. You can see him. That's a standard notion in the law, okay? The notion is that when you're inside your home, you have the right to defend yourself, your home, and the people inside of it with deadly force. All right, that's nothing new. That's nothing Florida invented. That's not even something America invented. So let's talk about 2005, because 2005 is going to be kind of the breaking off point in the analysis. And I want you to see what the law looked like before 2005. Before 2005, these are standard instructions that you would have received had you been a juror sitting on a case where someone was claiming self-defense of some kind or defense of property. And what you're going to see is that a defendant cannot use force likely to cause death or great bodily harm unless they had used every reasonable means within their power and consistent with their own safety to avoid the danger before resorting to that force, okay? What you're going to see is that basically you had a duty to retreat. A guy is coming at you, he's going to harm you. You can't just pull a gun and shoot him if you have an easy way to get away, okay? That was what the law basically said. And that notion is basically repeated in the second paragraph. Even if you're wrongfully attacked, okay? A person's coming to attack you, you haven't done anything wrong, someone just decides they want to make your day really bad for whatever reason. Even though you're being wrongfully attacked, you must attempt to retreat, okay? You must attempt, you cannot justify unless you have attempted to retreat. That was the notion that existed. Now, obviously, there's a caveat there. If by retreating, you would have actually put yourself in a worse situation, or if retreating was impossible, you were literally backed into a corner, then obviously common sense is going to take over and say, hey, you got to do whatever you got to do in that moment because there's no other way to avoid resorting to deadly force, okay? But the notion repeated again in that third paragraph is you have a duty to retreat, and under the Castle Doctrine, you'll see in the third paragraph, they carved out the one exception for the Castle Doctrine, which is if you're in your own home or on your own premises, then you had no duty to retreat. And what you're going to discover is that stand your ground is basically the opposite of the duty to retreat. I don't have to retreat, I can stand my ground. So prior to 2005, this was the case. A person gets attacked, a person is in danger, they have to try and get away if they reasonably can. If they can't, then they can resort to deadly force. And if the one exception is you're in your own home, then you can go directly to deadly force. You don't have to retreat. Your home is your castle. So in 2005, the Florida legislature decides to overhaul Chapter 776, which is a variety of statutes, which covers things like self-defense and defense of property. And it does basically two things. The first thing it does is it expands the places where you can stand your ground. The idea that you can stand your ground in your home without any duty to retreat, that you don't have to take any action to avoid the danger, is expanded to basically most places. You can be out on the public street. You don't have to try and run anymore. You can stand your ground. You're in a park, you're at the mall, you're at a movie theater, you're at your kid's recital, whatever the case may be. Generally, you have your stand your ground right kind of everywhere you are. There's a few exceptions, but pretty much that's it. The second thing it does, and Mr. Warren hinted at this, is it creates immunity for those who claim the justified use of force. And what that means when I say immunity means you can't be prosecuted criminally and you can't be sued civilly. Okay, so there's no wrongful death claim in civil court where the family's trying to get money because you killed their loved one, and there's no exposure of going to prison if you can claim the immunity. And as you'll see in a second, when we talk about it, basically it's really easy to claim that immunity, and then we have to have a hearing and a judge has to decide. So I found this. I thought this was really interesting. It gives you an idea of where stand your ground laws are enacted. There are places where it is limited. As you'll see, it's kind of the lighter orange. As it says, those 7 states have a limited version in stand your ground. But the unlimited version, like we have here in Florida, where you can basically stand your ground pretty much anywhere, has found its way to 24 states. And you can see where they are. They're pretty much clustered in the southeast, and in the northwest, northeast, and California are the obvious outliers there. So remember that there are 2 different standards of force to be used. And the first is non-deadly force. And non-deadly force can be hitting someone with your fist. It could be pushing them. It could, in theory, be stabbing them with a knife. It could be hitting them with a baseball bat. Whatever the case may be, it's always going to be factually dependent. But it spells out the standard for when you can use non-deadly force to defend yourself or another or your property. And basically, you have to reasonably believe that such conduct is necessary to defend yourself from the imminent use of unlawful force. Okay? So you get into an argument with someone and someone says, I'm going to kick your butt next week. That's not imminent, because in theory, they're saying it's going to happen 7 days from now. But he says, I'm going to kick your butt right now. You're in a whole different situation. It's one of the considerations is going to be the imminent use of unlawful force. And then you're going to see that any person who threatens to use such force in accordance with this subsection does not have a duty to retreat. That is the stand your ground notion. It doesn't say anything about being in your home anymore. It just says if you're going to use non-deadly force, in theory, as long as there's a reasonable belief of the imminent use of unlawful force against you, you don't have to retreat. Okay? Where it comes up more often, and you're going to see is a little more complicated, is in the use of deadly force. Deadly force is a higher standard. It's harder to justify resorting to deadly force. You're going to see again that a person's going to have a reasonable belief, but now they have to have a reasonable belief of imminent death or great bodily harm. So if a guy's coming towards me and he's going to punch me, I have the belief that there's going to be the imminent use of force. But in all likelihood, it's not going to be imminent death or great bodily harm. And we're going to talk about that because obviously if the guy coming at me was Mike Tyson, I might feel totally different about the level of injury I'm about to suffer from this punch. But if you believe that there's imminent death and great bodily harm, then you are allowed to use the force to prevent, or you can do it to prevent the imminent commission of a forcible felony. And I'll talk with you about what a forcible felony is, but you have basically an either or standard. You think you're going to get great bodily harm and death, or you think there's going to be a forcible felony committed against you. If either one of those are what you reasonably believe, then the person can use deadly force, but here's the tricky part. You cannot be engaged in criminal activity, and you must be in a place where you have the right to be. So if you break into somebody's home, you obviously do not have the right to be there. We're never going to get to that place. If you are engaged in criminal activity, same thing. And that oftentimes becomes what these cases rise and fall on, because you're trying to figure out is the person who used deadly force in a place they're allowed to be? Were they acting criminally at the time that they used deadly force? Many times that's the analysis, but it's not always. So you have these two things, and to help you kind of compare and contrast them, I put them here together so you can see them next to each other, and you'll see that the standard for non-deadly force is really much simpler to meet than the standard to meet for deadly force. They both have the reasonable belief, but one has the imminent use of force, and the other one has the imminent belief of death, great bodily harm, or forcible felony. And I spelled out kind of the most common forcible felonies there you might think of: murder, rape, robbery, aggravated battery, aggravated assault, kidnapping, arson. And if you don't know, aggravated battery, aggravated assault is where you either hit someone or threaten someone with a deadly weapon, or arson is where you start lighting stuff on fire. So if any of those things happen, you're already kind of moving in the direction of possible deadly force. You just have to make sure that you're in a place you're allowed to be and that you're not engaged in criminal activity. And that's the standard for claiming those things. And that's the standard a jury ultimately has to decide whether or not a person was doing the right thing, whether they were justified when they used the force. This is what they look at. So you may be asking yourself, well, what's a reasonable belief? Because if we sat down and talked about it, we might all come to slightly different standards. And in the state of Florida, jurors are given an instruction, which I've copied here so that you understand. This is part of the self-defense instructions you would see. And one of the things I think that's important there to note is that the danger doesn't have to be real, okay? You'll see that in a lot of cases, there'll be an argument about whether or not a person really was or wasn't armed, whether a person was or was not really going to hurt someone. And in theory, that's not necessarily the end of the equation. The question is, the person who is using the deadly force, the person who ultimately gets charged, did they actually believe the danger was real based on the circumstances, okay? And so that is a difficult thing. That is a difficult thing because you are talking about what is in the mind of a person at a particular moment in time. And it's very easy to sort of armchair quarterback on Monday morning after the game is played on Sunday about what should have happened during the football game. But in the moment, you know, what you see is not always the same. Well, it's the same idea in court. You go to court months, years later, and you start arguing about what a person did or did not believe, what they were or were not thinking in the moment that a trigger was pulled or a knife was stabbed or whatever the case may be. And you have to have this argument about, well, was the danger real? Was it not real? Did it matter? Did the person reasonably believe it? All of these things. And these are tough questions that prosecutors have to contend with and that jurors ultimately have to answer, or judges ultimately have to answer. And, you know, in the United States, people have the right to remain silent. You can't compel a defendant to answer questions or to tell you anything. So you can't assume that we're just going to say, okay, Mr. Defendant, get on the witness stand and tell us what you were thinking, and then we'll decide if we believe you. People, judges, prosecutors, jurors have to make this decision, oftentimes never having heard a word from the defendant. Beyond all of that, as if I haven't made it complicated enough for you already, when you're trying to figure out what is a reasonable belief, you have all of these other possible considerations that could come into it. The person who was killed, did they make prior threats? Do you have a situation where you know that the victim who ultimately died was indicating that I'm going to kill you, the next time I see you, it's over, I can't wait to find you on the street, and then I'm going to make you pay, whatever the case may be. These things are obviously important factors because you're trying to figure out what the person who ultimately used deadly force or used any amount of force, what they knew about what the victim had been saying before. Similarly, had there been specific acts known to the victim? Had the specific acts by the victim known to the defendant? A place that this, you know, might often come up is like a domestic violence situation where a wife kills her husband. And now you're going to have to maybe talk about, was the husband violent in the past? Was he the kind of guy who would beat her up? Had he done that in the past? Had he made threats to her in the past about the things he would do if he ever caught her with another man or taking the money or whatever the case may be? You have to start going back sometimes and sifting through maybe weeks or months or even years potentially of what's going on in the life between the victim and the defendant. You also can have considerations about the reputation of the victim. Reputation evidence in the state of Florida basically happens where you bring in people who will testify that in a certain community, whether it's a neighborhood or a church congregation or the local Boy Scout pack, whatever the case may be, the people in that community of people may know about the reputation of the victim. They may know him to be a violent person. They may know him to be a peaceful person. They may know him to be the kind of person who is quick to pull a gun because he always has one on him. Whatever the case may be, you've got all of these factors that have to be considered. And like I hinted at, there's obviously the Mike Tyson situation where you have to consider the physical capabilities. If your shooter, your defendant, is a 95-year-old little old lady, and your person who is dead is Mike Tyson in the prime of his boxing career, you can reasonably expect that that is a consideration in deciding whether or not the little old lady was justified in using force. But it cuts the other way. If Mike Tyson shoots a 95-year-old lady, you can say, well, I mean, maybe you didn't need to pull the gun, Mr. Tyson. And then the thing that often comes up, having done this a lot, is the aggressor problem. So let's pretend for a moment that Mr. Warren and I have an ongoing dispute. And I go over to him and I throw the first punch. I'm clearly the aggressor, okay? I've started the fight. But I'm only using non-deadly force in the moment. And Mr. Warren decides he's gonna pull a gun. And now that he's pulled a gun, I pull a gun and I shoot Mr. Warren. And so the question is, am I still justified? I started a fist fight. Mr. Warren decided to escalate it to a gunfight. And so I resorted in kind with a gun. And that can be difficult because you have to remember that in many of our stand your ground cases, either Mr. Warren or I are dead. And so you're only potentially getting the side of one person about who started the fight and how the fight escalated. The other option may be, I could go up to Mr. Warren, I could punch Mr. Warren, and I might be totally fine with it and say, ha, got you. I feel satisfied, and turn and walk away. He doesn't get to get out a gun and shoot me because I've withdrawn from the fight, right? Even though I was the aggressor, I withdrew from the combat. I decided to walk away. And so you can have all these considerations that come into play when you're trying to figure out whether or not a person is ultimately justified in the force they use, whether it's punching someone or shooting someone. And so the thing that's important for, I think, you to understand, and the part where this kind of all boils down to, is the change in the law in 2005 created the immunity hearing. And what Mr. Warren was talking about is that in the old days, before 2005, if a person wanted to claim self-defense, they claimed their self-defense at the trial, and the jury made the decision, okay? The lawyers before that engaged in discovery. We interviewed witnesses. We shared police reports. We traded photos and 911 calls and all the other evidence that we might see in advance. But ultimately, you went to a jury and the jury would sort it out. In 2005, what happened is the legislature created the immunity option, which gave the defendant the ability to seek an immunity hearing. And the immunity hearing happens before the jury trial, and it happens only in front of a judge, not in front of a jury. Okay, so in an immunity hearing, it's only a judge deciding. And in the immunity hearing, the burden is on the state to disprove the defendant's claim that the defendant was acting in self-defense. That's what Mr. Warren is talking about when he says having to prove a negative, okay, or disprove a negative. So that can be very difficult because as you'll see on my PowerPoint, a defendant doesn't have to put on any evidence to trigger an immunity hearing. Basically, the defendant says, I was acting in self-defense, go ahead and prove I wasn't. Defendant doesn't have to put on any witnesses, doesn't have to present any videos, put on any photos, nothing. Defendant says it, and then the burden falls on the state, meaning we bring in our witnesses very much like we would do in the normal jury trial. You have to put on all the witnesses and the evidence to prove the defendant wasn't acting in self-defense, and we do it by what's called clear and convincing. That's the standard. And if you see at the bottom there, I kind of put the hierarchy. Beyond a reasonable doubt is the highest burden. That's the burden to convict someone of a crime. That's what you have when you go to jury trial. Preponderance of the evidence is the more likely than not. If you think of it like the scales of justice, you just have to have one side ever so slightly leaning more than the other. Okay, more likely than not. And clear and convincing exists somewhere in the middle. It's not quite as high as reasonable doubt, but it's definitely higher than preponderance. Most people would say it's significantly higher than preponderance. So that falls on us. The thing that is interesting about this is that if a defendant claims self-defense, and if we have an immunity hearing, and if the state meets the burden of clear and convincing and disproves the defendant was acting in self-defense, the defendant still gets to claim self-defense at trial. Even though the judge says, I didn't find you were acting in self-defense, okay? The defendant still gets to claim self-defense at trial because the jury then has to decide. And as you can probably figure out, if a defendant doesn't have to put on any witnesses, doesn't have to put on any evidence, doesn't have to testify himself or herself, and all the burden falls on the state, there's really kind of no risk to claiming self-defense. At jury trial, it's a little different. You have the jury that has to decide, and the judge still has some say. And the state still has to disprove that you were acting in self-defense. We have to do it beyond and to the exclusion of reasonable doubt. So in theory, if we can do it at trial, we can do it at the hearing. But like Mr. Warren was saying, you have to bring in all of these witnesses, many of whom are law enforcement officers. You have to bring them in for the first hearing, take them off the street. They're not out patrolling neighborhoods. You bring in the victims. You put them through this once before, or the victim's family, whatever the case may be. You put them through this in the immunity hearing. And then you still have to go through it all again at the jury trial. And the defendant gets to make the same claim. And you don't get to say, well, we had an immunity hearing and the judge didn't believe you. You don't get to bring that up. So the jury just has to make the consideration totally on what is presented there in the courtroom, not whatever happened at the immunity hearing. So that kind of gives an overview. Hopefully I didn't bury you all too much with facts. Let me stop sharing this real quick, and so I can see. I want to open it up to questions. I'm sure you all have lots of questions. So I don't know who the moderator is here at this point, but I'll field questions if people have questions.
Justin and Mr. Warren, in light of the time, we have a couple of questions that we've had that were pre-planned, and this is for either of you. Can you give us a little bit of an idea of what happened in the legislature in 2005 that actually caused this law to come about and be placed on the books? And then overall, was its intent fulfilled? Did it solve the problem that was trying to be solved or attempted to be solved?
Well, I think Mr. Warren talked about this. The legislature presented this as a notion of there were people commonly framed as, lawful gun owners who were being prosecuted for what were otherwise justified shootings and were being made to undergo the expense and the heartache of going through the criminal justice system and ultimately having to go all the way to trial before they were vindicated. As Mr. Warren said, that simply is not the case. There wasn't this army of people, lawful gun owners, who were being prosecuted and undergoing this heartache. But the legislature, under the belief that that was happening, created this immunity hearing so that basically a defendant could get to an immunity hearing much faster than a trial, and the case could ultimately be thrown out when you could show a judge that this person was acting totally lawfully and was totally justified and should never have been arrested. So I think that was kind of the intent. I think in practice, what we have seen is we have seen a lot of domestic violence cases, husbands and wives, the only people in the house alone. The husband beats up the wife or the wife beats up the husband, whatever the case may be. And you've got two people in a room and it's very easy for each of them to start doing this. The wife says he beat me up and the husband says, no, she hit me first. And I don't think that was the intent. Having been in Project Safe Neighborhood, I saw a lot of cases that were not lawful gun owners who were still shooting people. And unfortunately, the law says that you can't, if you're a convicted felon, generally, you can't walk around with a gun. But there is sort of a caveat that if there's a gun nearby and you're getting attacked, you can't pick up a gun and defend yourself in this kind of weird universe. And so you'd have people trying to pigeonhole or bang square pegs into round holes. And it becomes the state's obligation then to say, well, that's not true. And let me show you why. And that can be difficult. And it can be very difficult because in many of these cases, what you end up seeing is victims don't want to come to court, especially when you have gang cases where you have one gang member shooting another gang member. They just want to resolve it on the street. They don't want to come to court. They don't want to be snitches. So I got to get them not just to court once. I got to do it twice now. Not to mention that they have to come for their deposition and whatever other motions might happen. And so it just turns into a rolling problem of trying to get these people into court, where it makes it harder to deal with people who are many times, violent people, gang members, things like that. It gets hard to get the victims in here sometimes. And so I think it creates a greater hurdle more than it fixes any problem.
And Justin, let me just add to that. There have been studies done of the impact of stand your ground. And this is from a 2017 study. So it was before the law changed most recently. That made it even harder for prosecutors. But in Florida, the implementation of stand your ground was associated with a 32% increase in gun homicides, a 24% increase in overall homicides. And so you're seeing both justifiable and unjustifiable homicides go up. Nearly 80% of stand your ground cases in Florida, the assailant, so the accused, could have retreated to avoid the confrontation. So what it's doing is it's allowing people just to shoot first rather than avoiding it. And as Justin talked about before, it's not like if you're in a situation where you felt like using deadly force was appropriate, you weren't allowed to use it. It was just if there was a clear case where you could have retreated, you had a duty to retreat. Now, there's no duty to retreat, so we see a huge increase in these confrontations. I said 80% of the time, it's estimated that the person could have retreated. And in 70% of cases, or nearly 70%, the person killed was unarmed. So you're often seeing people with guns kill unarmed people claiming, well, he punched me, so I felt like I had to shoot him back and kill him. There's been no evidence that it actually reduces crime. As both Justin and I talked about before, there was no evidence that there was some problem with people wrongly being prosecuted in the first place for it. And at a time when we're all talking about racial disparities in the criminal justice system, studies have shown that the odds of a white on black homicide is 3 times more likely to be found justified than a white on white homicide. So that's just for white defendants, meaning white individuals using deadly force against others. They're 3 times more likely to found to be justified when they're using against a black person than against a white person. These are the types of things that exacerbate racial disparities in our system.
And Kirk has a couple of questions coming in. If everyone, I think we have a few more minutes left. There is a chat room at the very bottom if you want to ask your question. And while Kirk is going over those, one last question from me for either Mr. Warren or Mr. Diaz, and not to put you on the spot, can you give us an idea for year to date how many times Stand Your Ground has been utilized in Hillsborough County, or potentially last year, to give us an idea of volume, just in approximate numbers?
Jeff, I wish I knew the numbers offhand. We actually, when the law was first changed in 2017, we started tracking it. Mm-hmm. And I mean, it's being raised in literally thousands of cases. We don't have that many hearings go, but it's because the vast majority of cases in the system end up pleading out. But we see an extremely high rate of cases that go to trial, where there's a stand your ground defense, stand your ground hearing in these violent crime cases. Often in the violent crime context, we see really 2 defenses. It wasn't me, or it was justified. Or someone's claiming it wasn't me, they're usually not going to say, I was there and acted in self-defense, but we have seen it. And Justin hit this point on its head before. The information that comes out in the stand your ground hearing can't always be used in trial. So someone can assert stand your ground, hey, I'm not saying I was there and you got the wrong guy, But if I was there, I acted in self-defense. So we have to go and refute that argument. And then we get to trial and the person says, well, I wasn't there whatsoever. We're like, well, you told us before that you were there and acted in self-defense. Nope, can't use that. I mean, it just creates like a legal morass in some of these things.
Yeah, and one of the things I want to make sure, because I didn't really explain it, Mr. Warren's twice referenced 2017. Before 2017, we had the immunity hearing, but courts were generally holding that a defendant at least had to make some sort of presentation of evidence to establish that he was acting in self-defense. So put on some witness or something to at least establish it. In 2017, what they did is the legislature said, no, that's not what we intended. We intended for defendants to have to not present any evidence. We don't want that. We don't have to present anything. It's all totally on the state, and it should always be on the state. And so that has only further increased the number of places where a defendant is likely to claim self-defense. Because again, now they don't have to put on anything to claim self-defense. They just got to say, hey, it's self-defense. Good luck. Try and disprove it.
Okay, and I think, thank you, gentlemen, for both of that. Kirk had a question, but I think it's been answered. Do they find that public thinks that this is some kind of shield from prosecution and they misinterpreted that? I think you both have answered that in terms of that may in fact be a yes. Is there any indication to you that this law may be challenged or reversed for either of you in the up and coming future?
I don't expect it will be reversed or challenged. I think it's been through the courts, and the courts have pretty much had to hammer this out for a variety of reasons. I didn't even talk about, there was a whole argument about whether or not the change was retroactive or only went go forward. And so I think it's here. It could get changed, obviously, but it's going to have to get changed through the legislature. It's not, I don't foresee it going anywhere because the court deems it unconstitutional or improper in any way.
The one legal issue that is still outstanding is Justin talked about to invoke stand your ground, a defendant has to do nothing. There was a dispute about whether the defendant had to put forward some argument of self-defense, like the slightest bit of even admitting that they were there and I acted in self-defense. Like if someone just has to say, yep, I was there and I acted in self-defense before the burden shifts to the government, to the state to prove. But the courts have basically said, nope, someone just has to, state the magic words and all of a sudden the state has this additional burden. So hopefully as those cases wind through the courts, our courts say there should be some minimal burden to trigger the burden shift to the state to have to now disprove that defense.
Okay. Well, thank you, gentlemen. If there is no other questions from the group, we will, again, thank you for joining us. We hope to do this on a reoccurring basis. I know you are busy keeping us safe, but we have now a myriad of topics that I'm sure the public would love to hear about, and we'll certainly be reaching back out to you to go over those and potentially schedule an additional or two Zoom events for the remainder of the year. Betsy, do you have any questions or comments?
I just wanted to pop in. I'm the community outreach specialist over at the Tampa FBI field office. So I wanted to thank you both for coming out to present today and to talk to our Citizens Academy members. I'm brand new to the position, so you're actually the first event that I've helped Citizens Academy put on. So just wanted to say thank you. Thank you for taking your time. It's a very interesting topic. It's obviously one of the very hot topics that are happening right now in our communities. So it's great that we can be relevant and find out up-to-date information. So thank you so much.
Thank you for having us.
Our pleasure.
And Kirk, I think, Terry, did you have a question, Terry Wallace? No? Okay. Then with that, we'll go ahead and wrap up a few minutes early. Thank you, gentlemen, for your time and what you do and how you keep us safe. And we will hopefully reconvene again before the end of the year.
Thank you so much.
Thank you. Have a great day.
You too. Bye-bye.